All right, let's switch down to the far table and talk about another phase of this access issue, to talk about the trial court judges and the experiences that the trial judges have had in several different settings. Chancellor Bonnyman, you serve in the Chancery Court here in Nashville, which primarily hears business cases and government cases and employment cases. Can you tell us how often you see self-represented litigants, litigants without lawyers, come in and give us a few examples of kind of the experiences and the first encounters and where you go from there?
Okay, I know I don't have a long time to talk, so I'll speed ahead here. Chancery cases, as you said.
Can you pull your mic a little closer to you? It's the one in the middle, I think.
All right.
Yes.
Okay. Is that better?
Yes.
Okay. Chancery cases are diverse, they're complex, they're not routinized for either the court or the litigants. I've been on the bench for 10 years, and among the most difficult cases for me and for my other Chancery colleagues, circuit court too for that matter, are those in which one or more of the parties do not have a lawyer. I'm grateful to everyone here for focusing attention on the serious challenges raised for the adversarial process in such cases. Again, after 10 years as a trial judge, I abandoned the idea that I could even the playing field some way. Instead, I try to focus on reaching the merits of each case, and that often means allowing the self-represented person, and of course the represented person, to tell their story. The other task, of course, is making sure those merits, the story, gets in the record, and these are two difficult tasks, and both of them are time-consuming, especially when someone is not represented. There are at least three major barriers that I see in Chancery when a party is not represented. The first two run throughout the literature for access to justice cases, and you're familiar with them. The self-represented party cannot educate the trial judge, and given the complex cases that we have, expecting the judge to explain the burdens of proof and the elements of the claims can result in misdirection, but you could sure try. Second, the self-represented party cannot navigate the rules of civil procedure or rules of evidence, and Matt Sweeney and I have talked about that. Third, the unrepresented party does not have judgment and perspective about his case, and this is something that I don't hear much said about. On a recent Friday motion docket, a well-known and respected lawyer argued his personal case against his former law firm passionately and bitterly. Without a lawyer, he could not protect his credibility or save face or benefit from perspective and judgment. It was sad and thought-provoking to see how poorly he was managing his lawsuit, even given that he was trying to exercise his considerable skills as a lawyer. We know that the self-represented party can himself be the barrier to addressing the merits of the case. As a corollary to this issue, I do not ask or direct self-represented people to go to mediation. I did that for a long time, and then I saw that they don't settle. And I think that's because the unrepresented party does not have the judgment, the confidence, or the trust to come to a mediation where the other side is represented by a lawyer and think that he or she is going to get something that makes sense. Unrepresented parties in Chancery are not completely indigent. I mean, they're certainly not all indigent. Most are working people who have little connection to lawyers. They can probably afford some help, but they don't think they can. And in the beginning of the case, they don't perceive that they have exposure or that there's real liability. Whether they're plaintiffs or defendants, however, they do have something to lose. If there's an event and a self-represented party appears at the event, the trial judge has the opportunity to give the party some extra time to slow things down a little bit. And that's always been a friend, I think, to trial judges, is don't rush. Slow things down a little bit so that the party can go see a lawyer, the motion can be reset, the party can buy, often it has to be bought, a consultation with the lawyer in their area of the law. And sometimes the party will come back and say they've hired a lawyer, or the lawyer comes in and says that. It's a time to rejoice. But slowing the pace is worthwhile. It's also very common for the party to come back to the court after having been to numerous places and say, I can't afford to pay the fees. I don't qualify for anything. So what about the application? Matt asked me about the rules of civil procedure and the rules of evidence. the rules of evidence, in my experience, do not necessarily obscure the merits or this person's story. Because in a bench trial, I'm not talking about jury trials, but in a bench trial, the trial judge can relax the rules for both sides. And I try to advise the lawyer on the other side that just because I admit a document, and the document seems to have some merit in the case, some attachment to the case, it doesn't mean I'm going to rely on it, but I will freely admit exhibits from both sides. And I get a lot of cooperation from the lawyers. I really haven't had any trouble in a bench trial with admitting papers that tell the party's story. And then I remind the lawyer, well, you know, you're trying to get this damaging exhibit in and it's hearsay. I'm going to let it in. So people don't seem to be that unhappy if they're kind of treated the same way. The judge has to assist a plaintiff who will testify but does not have a lawyer. And boy, I can sure use the role playing. If I do not probe and ask questions, then the plaintiff has only a narrative, and the plaintiff's just going to get up there and stop talking in a freewheeling way, and that's not fair to the other side. So on occasion, I almost always ask the questions, a lot of questions, but on occasion, I will use that party's pleading to get questions from, to ask, is this true or is that true? Or explain this or explain that. The rules of civil procedure, as you all know, are more problematic because even if an unrepresented party comes up with a decent answer, maybe even a counterclaim, then you still have the party who understandably files a motion for summary judgment and request for admission. So I do have the opportunity and have done this, although it's certainly not ideal, to ask the party who comes to court to respond. And that happens a lot. Doesn't file anything, just comes to court to respond. To tell me what they would say or what they do say, and then ask them to write it down, take it to the clerk's office, and file it. And again, slowing things down a little bit helps. A lawyer who knows the local rules and complies with them is often irritated when the judge doesn't apply the local rules, but I don't think it's fair to apply the local rules to a self-represented party, because how can they know what the local rules are? How can they find them? How can they understand what they're for? So again, slowing the pace is helpful and does no harm. I will ask the lawyer, if the party comes to the motion docket, I'll ask the lawyer to reset the motion and let the person tell their story in a handwritten document and file it in the clerk's office, and then we can take that up when the motion comes back on the motion docket. And the lawyers they're not delighted, but they're cooperative. They're reasonable people. There can be unrepresented people on every side of a contract dispute, and I've had that situation. I adjudicated a number of business disputes in which both sides were from a culture different from what we see in this room. The business disputes had Koreans on both sides, Africans on both sides. Another case had Arab speakers on both sides. These lawsuits are very time-consuming. You can get to the merits if you can just understand what the problem is, because you don't have a lawyer framing any of the issues. The case is extra confusing when the real issue is general unhappiness with the business relationship. So it's talk about losing control. You don't really have a form, not a form to use, but you don't have a form of the issue, and it's just really time-consuming.